According to plea, punishment is to be assessed at 4 years in the prison. There is no application for deferred adjudication. State opposes your application for community supervision. They will take in consideration NIMAG number 701585, 22 CR 10886, State of Texas versus Thomas Marsh. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Ryan Wolf for Thomas Marsh.
And are you Mr. Marsh?
Yes, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Marsh, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're waiving the enhancement allegation paragraph,
Any objection?
No objection.
but otherwise proceeding on the indictment.
All right, thank you. Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of possession of a controlled substance penalty group 1 gram to 4 grams? That's a third-degree felony.
Yes,
Range
ma'am.
of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes.
Mr. Marsh, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to plea, punishment is to be assessed at 4 years in the prison. There is no application for deferred adjudication. State opposes your application for community supervision. They will take in consideration NIMAG number 701585. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, were there any such motions?
No, Your Honor.
Then to the offenses charged.
In a serious and emotional courtroom moment, Thomas Marsh officially pleaded guilty to a third-degree felony charge for possession of a controlled substance, acknowledging responsibility before the court as the case moved toward sentencing. The plea agreement presented to the court included a recommended punishment of 4 years in prison, while prosecutors strongly opposed any request for community supervision, signaling the state's tough stance on the offense. Throughout the hearing, the courtroom remained tense as both sides debated whether Marsh deserved an opportunity for rehabilitation or should face immediate incarceration. Judge Stephanie Boyd carefully reviewed the agreement and accepted the guilty plea, but she stopped short of making an immediate final ruling on punishment. Instead, she ordered a comprehensive pre-sentence investigation report along with a treatment alternative to incarceration program evaluation, showing that the court wanted a fuller understanding of Marsh's personal history, criminal background, and potential for recovery before deciding his future. The hearing highlighted the difficult balance courts face between punishment and rehabilitation, especially in drug-related cases where addiction and repeat offenses often play a major role. With sentencing scheduled for May 18, uncertainty now surrounds the final outcome of the case. Marsh could still receive probation under strict supervision if the evaluation support rehabilitation, or the court could move forward with the agreed prison sentence. The decision now rests on whether the judge believes he has a realistic chance to change his life outside prison walls, making the upcoming sentencing hearing one of the most critical moments in the case.
how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offers states exhibit 1 in all attachments.
All right, thank you.
To the-
Your
Mr.
excuse.
Board.
All right, Mr. Marsh, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. This will be set for sentencing on what date, Ms. Ferguson?
I think.
And I'm gonna,
Do May 18th.
all right, we're gonna come back on May 18th for your sentencing. I'm gonna request the PSI and TAP. I will base my decision on your application on the PSI report that I received and any other evidence that's presented to me. All right, good luck to you.
As the courtroom proceedings came to a close, the future of Thomas Marsh remained uncertain, leaving a heavy tension hanging in the air. What began as a routine plea hearing slowly transformed into a critical moment that could ultimately decide the direction of his life. With prosecutors pushing for prison time and the defense hoping rehabilitation could still offer a path forward, the case now stands at a crossroads between punishment and redemption. Every detail presented in the upcoming reports and evaluations could play a major role in determining whether Marsh is given another chance under strict supervision or ordered to spend years behind bars. Judge Stephanie Boyd made it clear that the court wants a complete picture before making a final ruling, ordering both a pre-sentence investigation and a treatment alternative to incarceration program evaluation. Those findings may reveal whether Marsh has the ability to successfully rebuild his life outside of prison or whether incarceration is the only appropriate outcome. The hearing highlighted the difficult decisions courts face in drug-related cases, where addiction, accountability, and public safety often collide in emotionally charged proceedings. Now, all eyes turn to the upcoming sentencing hearing on May 18th, where the final decision will be announced. Will the court believe rehabilitation is still possible, or will the agreed prison sentence become reality? The answer could permanently shape Marsh's future, making the next courtroom appearance one of the most important and dramatic moments in the entire case.